Hello friends, Namaskaram. Today I am going to discuss the important update regarding the prosecution and acquittal of the accused in cases under section 307 of the IPC. Friend, as you know that basically this section is concerned with the attempt of a person to kill a man or a woman or an individual, means a natural person. In that connection, Honorable Supreme Court in a recent judgment titled as Raju versus State of Uttarakhand, which is a recent judgment by Honorable Supreme Court that has been pronounced on 31st of July 2024, detailed guidelines has been passed and pronounced. In this case, the FIR was registered under section 307-34 of IPC. Ultimately, the accused persons had been charge sheeted and finally charges were framed. The prosecution inter alia examined certain witnesses. They were subject to the cross-examination by the concerned accused person's counsel, and apart from that, the statement of the accused has been recorded and finally the accused persons had been convicted. They moved before the Honorable High Court, but inter alia their appeal has been rejected. Finally, they submitted the petition before the Honorable Supreme Court for vindication of the grievances. Their basic concern is that there is no evidence in this case. If the case is based on hearsay evidence, the case is totally a weak case. In that scenario, the accused could not be convicted in such type of cases. Their point is that the testimony of the concerned witnesses is suffered from major contradiction. If the major contradiction exists in that scenario, the concerned accused persons cannot be convicted because the prosecution is bound to prove the case beyond reasonable doubt. If the prosecution failed to do the same in that scenario, the accused could have the benefit. The primary key is that for section 307 of the IPC, the intention to kill must be on the record. If the intention to kill is not on the record, in that scenario, the accused could not be convicted under section 307 of the IPC. As we know that there are two things: culpable homicide and murder. For culpable homicide, knowledge is important, and for murder, intention is important. So basically, section 307 of IPC is the second format of murder in which the attempt is itself made punishable under the law, but the key point is that the intention should be on the record. Without intention, the said section could not be robbed in, could not be imposed on the shoulder of the concerned accused. Apart from that, he submitted that the person who lost the FIR is not the eye evidence, means the FIR is lost by hearsay evidence. So such type of FIR is totally polluted and cannot be relied upon, being suspected. And apart from that, the testimony of eyewitnesses are highly contradicted, and apart from that, their testimony is not going to be matched with the medical record. He submitted that the medical opinion in such matter is quite important. Apart from that, witnesses are saying that certain weapons are used in inflicting the injury, and apart from that, the medical opinion submits that no such injury is possible by the use of such weapons. In that scenario, it is quite clear that the concerned eyewitnesses are not giving the proper version of the incident as it happened. So the prosecution is bound to prove the case not only beyond reasonable doubt, but in such cases the motive is also important. If the motive is not specified in that scenario, it is totally fatal for the case of prosecution. So in this case, looking to the fact and circumstances, the court has passed the judgment of acquittal, but in the present case, we could learn the following 15 points from the case. Number one, there are two things: culpable homicide and murder. Culpable homicide becomes murder if certain exceptions are fulfilled which are given in the act itself, for which you may peruse section 300 of the IPC. Number two, if you are going to say that you are not having an intention, the burden is on you, but the burden shifts when the prosecution is duly proved the case in the light of section 101 of the Indian Evidence Act. Section 106 of Indian Evidence Act comes into motion when you are having a specific defense. Number three, sudden fight, immediate provocation does not constitute murder, and that's why for their attempt, the person could not be charged with section 307 of the IPC. Number four, the intention is quite important. Intention is not there. In that scenario, the accused could not be convicted for section 307 of the IPC. Number four, the person who is going to lose the FIR is also important. If the concerned complainant is not the eye evidence, then in that scenario, it is a serious blow on the case of prosecution. Number fifth, the person who has witnessed the evidence are true evidence or not, it is required to be examined by the concerned defense, for which the concerned defense, while doing the examination, may do things in examination in such a way so as to cause the proper contradiction in their testimony or versions. Next point number 6 is that the medical version is also important. If the medical version is not going to be matched with the case of prosecution, in that scenario, it is a serious matter, in that scenario the prosecution can be deemed to be non-genuine. Number 7, if there is a major contradiction and there is no explanation by the concerned prosecution regarding the same. For example, if one is saying that certain articles are used and other is saying that these articles are used, there is a variation, and apart from that these variations are not going to match by the other witnesses who claimed himself or themselves to be the so-called eyewitness, in that scenario we could have the benefit. And apart from that, the identification of the accused is quite important, that is point number 7. If the accused is not properly identified, apart from that there may be a dark wherein the incident has been happened, in that scenario the concerned defense could have the benefit easily. And apart from that, we must know that the concerned eye evidences, if giving the different version in the cross examination, in that scenario it is a total fatal situation for the concerned prosecution, because whatever they are going to depose in the report, if differ in their examination in chief, and apart from that in cross examination they are going to set up a different case, then easily we could have a benefit. Point number 9, in such type of FIR, do not act in anxiety, just wait, read the FIR, and you might submit the Gyapan or memorandum also, because in case charge sheet is filed or you are planning to move for the questioning or you are going to move for discharge petition, then these scenarios are quite important for you, because once anything is submitted to the concerned prosecution agency, the agency is bound to consider same in the light of fair investigation theory. If the things are not going to be considered, you may take the plea that they submitted you towards the unfair investigation. Point number 10 and 9, we are going to combine it. The key point is that the medical opinion is also important, because if the concerned jurist is of opinion that such injuries cannot be inflicted by using the instruments or weapons which is suggested by the concerned witnesses, that is very important for us. Number 11, the concerned defense is bound to examine the case in the light of the fact that whether there was a sudden provocation or whether the concerned knowledge or intention is there or not as averted by the concerned prosecution. If it is not there, then you could easily have the benefit, because major contradiction is one of the basis to get success in such type of cases. Point number 13, you must remember that while doing the examination, remember one thing, the report, the further proceeding and the statement of witnesses are quite important. Causing major contradiction, causing variations is the point of winning. Number 14, if the concerned complainant is having any criminal background, then you may contradict his image or his life practice or life history in the light of section 145 of the Indian Evidence Act. And apart from that, last point is that the motive. If motive is not there, if intention is not reflected from the facts, in that scenario you could easily claim the benefit. So in this case, when the accused are acquitted by having the said scenarios, you could easily claim the same. But the point is that you must emphasize that in which manner the case is drafted, grafted and internally submitted in the court of law. If we are able to do the same, then definitely we could have the benefit. So no need to worry, just fight about your rights and definitely we will win. So see you in the next video. Till then, Jai Hind, Jai Bharat.